Hi there, I'm Susan Parker with OTAC, and I'm here to talk to you today about Ferpa. So you've heard that term, I'm sure, that acronym, Ferpa, Ferpa, Ferpa. Just what is Ferpa? Well, it is the Family Education Rights and Privacy Act of 1974. It's also known as the Buckley Amendment. That's just a little background information for you. Actually, it's a federal law designed to protect the privacy of education records. What does this law do? This law guarantees students the right to the things that you see on the screen there. Inspect and review their education records, mend those records, have those records disclosed to certain people, and also it gives students and parents the right to file a complaint with the Department of Education if they feel like those rights have been violated. Actually, parents or eligible students, those are students 18 years or older, must submit a written request to the school to request those records, and your job at the school is to comply with that request within 45 days. And this is interesting. By the way, these FERPA rights continue after the student leaves school and are really only terminated upon the written request of the parent or student or upon death. So they're set in stone, actually. So who is required to comply with FERPA? Why would you do this? Well, all educational institutions which receive federal funds must comply, and it's the law. There's another reason. And then the other thing is failure to comply could result in removal of some federal funding. You wouldn't want that to happen. So that's why you comply. So what can be released? Well, the information you see here on the screen, directory designated information, information the student or parent has provided a written request to release, information requested by school officials who have a legitimate educational interest is another way these records can be released, and then information requested by certain government agencies. And directory designated information is particular to the student and is typically not considered invasive to the student, so it could be released without prior consent. Now, there were some changes in January of 2009. These are new regulations that went into effect, and many of them were clarifications to the previous regulations, and actually this all came about after the tragedy at Virginia Tech, where the university administrators were unclear about their duty on releasing information, and so that's why this all came about, all these changes came about. So the Department of Education took this opportunity to ensure that FERPA regulations reinforce the safety of the students. So here are some critical changes that you see on your screen. The new regulations contain a multitude of amendments to the prior regulations, and some which are critical, like these you see, and others which merely codify what has become accepted practice. And these are the changes that we're going to address in this webcast today. So the first thing I wanted to address, the definition of attendance has changed a little bit to catch up with our technology these days, and basically it's expanded to include distance learning, education modalities, and also work study. So that means any student who is enrolled in any of your classes but may not be physically present at the school, for instance, virtual classes via internet, correspondence, video conferencing, any other kind of telecommunications kind of technologies. If the student is enrolled, then that's when these FERPA rules and laws come into effect. This also includes the period of time in which a person is working under a work study program. So if you have a student, actually, not just if they're working, but if they are actually enrolled for credit in a work study program, then these kinds of rules apply. The types of information you see on your screen are the types of information that is considered directory information. And here's some examples. These vary sometimes greatly from district to district, from elementary, middle to high school as well. And throughout my research for this webcast, I kept wondering why the term directory information. Well, basically, it's information necessary to publish such things as honor rolls, athletic programs, conduct the awards assemblies that you have at school, et cetera, all that kind of thing. So actually, it did surprise me that some of this information can be released without prior consent. But remember, this law is concerned with education records, and so these types of information can be released as long as is it is not attached to an education record. So as long as it's not the same piece of information or in the same location, it can be released. And remember, this information should only be released to school officials with legitimate education interests or educational interests, and then parents also can notify the school in writing if they don't want any of the above information released. So, and usually you have all of this specified in your handbook along with the forms available for the parents if they don't want any of this information released. Now I'm showing you this list again on the screen, and you can see that there's 3 areas that are underlined here: the student name, activities and sports, and honors and awards. Actually, it's up to you to decide in your district of this directory information what you are going to release without prior consent. And actually, those 3 items there is what one school district decided, hey, that's all we're going to release unless we ask the parents first. So it's your decision to decide of that list of directory information what you'll allow to be released without the prior consent. So now then we get to non-directory information. Well, what is that? These items here on the screen, like the Social Security number, student ID number, race, ethnic groups, nationality, transcripts, grade reports. These are things that you would never, ever publish without permission. Further, faculty and staff can access this non-directory information only if they have a legitimate academic need to do so. What you see now is what changed in the definition of directory information, so you can understand what's the difference now from the prior years. And basically, now the law prohibits the disclosure of a student's Social Security number, flat out prohibits it. It also prohibits student identification numbers or ID numbers used, can only be used with a personal identifier. So what does that mean? So basically, student IDs can be used in directory information provided the ID number cannot be used to gain access to education records except when used with one or more factors to authenticate the user's identity, like a secret password or a PIN number, something like this. This change then ensures that institutions can use advanced technologies to deliver student services and access education records, whether electronically, by phone, or in person, because you have that extra stopgap of the password or the PIN number. So I'm going to continue with some of the definitions that are now better defined, and I'm going to address personally identifiable information. So what is that? What are we talking about there? Well, personally identifiable information are those kinds of things you see on the screen, and these are just better defined in the new law. So even though some of this information that you're seeing right now could be directory information as well, remember we're talking about information that is attached to an education record, not just by itself, but attached to an education record. So personally identifiable information is information requested by a person who the institution reasonably believes knows the identity of the student whom the education record relates. That's the new definition. So this statement is just saying that you should not release that education record with the personally identifiable information on it to, say, an aunt or a cousin or a member of the church congregation or another student unless you have prior written consent. And you always come back to that. As long as you have prior written consent, you're probably okay. But this is something to think about when you're utilizing parent or student volunteers in your classrooms. Having them grade papers probably would not be appropriate because they're going to know a student and they're going to see information on an education record that they probably should not see. And really, many of you in smaller communities where everyone knows everyone else probably should be even more cautious about releasing education records with that personally identifiable information unless you have prior written consent from the parent or guardian of the student. So always go back to that. This also has changed, and personally identifiable information biometric records was added to that now, which is things like fingerprints, DNA. That these kinds of things were not included in the law previously. So see, some of this law just clarifies what we might already know or be using. Here's another statement to kind of think about. Other information that alone or in combination is linked or linkable to a specific student that would allow a reasonable person in the school or community who does not have personal knowledge of the relevant circumstances to identify the student with reasonable certainty. That's how it's actually stated in the law. So what this is saying, that if someone can put two and two together and with some of the personally identifiable information and figure out who the education record is about, you should not be releasing that info without prior consent. There you go back to having that prior consent from the parent or the student themselves if they're over 18 years of age. Now this law, like I mentioned before, prohibits using the Social Security number as an identification element when you're disclosing or confirming directory information. So in other words, you couldn't use the Social Security numbers on, say, a sign-in sheet or when posting student grades. You don't want to do that. Now you still can use class lists with ID numbers, but you cannot make them available to students or parents. You can use them, and within your system you can use them. You just can't make them available to students or parents. And if you're still one of those teachers or instructors that post grades publicly, you have to use a code known only to you and the student. And you might want to list the grades randomly and not in alphabetical order. So that's just another way that safeguards that information being identified or somebody putting two and two together. So now we're going to talk about education records as one of the other critical changes. So what are these education records referred to in the law? This means written documents, computer media, video, audio tape, photographs, electronic files, and such that are directly related to a student. Now there's always exceptions to everything. So what is not an education record? Well, as you see listed on the screen, records that are kept in the sole possession of the maker. Your own little scribbling notes that you keep at your desk or to help you keep track of a student's progress, those kinds of things are an exception. They're used only as a personal memory aid, and they're not accessible to anybody else. They're just your notes. So that's an exception. That is not called an education record. Now here's some other exceptions. Law enforcement records, employment records. Now these are employment records when a student's not in a work-study program, but they're employed somewhere, but not connected with a credit, let's say, at school. Medical records, alumni records. These are all exceptions to what is not an education record. Alumni records, for instance, are created after the student has left school. So in other words, these types of records or information are not considered education records and therefore are not restricted by the Ferpa law. These records don't need the student's or parent's permission to access them, mostly because these records are only being accessed by very specific groups, like the medical profession, emergency people, employers, things like that. This is a new exception to the definition of education records, and this was added as a result of a U.S. Supreme Court decision actually occurring here in Oklahoma, in Owasso, and it concerns peer-graded papers. And what the law says is peer grading does not violate FERPA laws. So this exception excludes those peer-graded papers that when students trade papers in the class before they are collected and recorded by a teacher. At that point, you're not in violation of the law. And just a sidebar here for you to remember, this really has nothing to do with the law, but it might be helpful to you. There are studies that show that while peer grading might be a time saver for you as the teacher, it does not necessarily result in an increase in student learning. And so a better twist on this might be for you to have students correct their own assignments, but maybe as a group, so they're learning from each other, but they're correcting their own assignments. So just kind of keep that in the back of your mind on how to handle that in your classrooms. This also is the other clarification in the education records, and these are records created or received after the student leaves the institution. And I'd mentioned this earlier. This is kind of like alumni information. The person wasn't a student, and so if you've added them to an alumni list, that's not an education record, so it's not protected by FERPA. Now we're coming to one of the last critical changes we're going to address in this webcast, and that's the health or safety emergency information and the role of parents and disclosures to the parents, students. So here's what the law says. An education agency or institution may disclose personally identifiable information from an education record to appropriate parties, including parents of an eligible student, and an eligible student, by the way, is a student who is 18 years or older, in connection with an emergency if knowledge of the information is necessary to protect the health or safety of the student or other individuals. So really what this section, why this section was added was to add some flexibility, really, for the institution. It permits you as a school institution to take into account the totality of the circumstances pertaining to the threat to the safety of the student or to the emergency situation when you're deciding to disclose information that normally probably would otherwise be protected. So it gives you the leniency to go ahead, release that information that's going to help emergency officials with the situation that you're experiencing at that time. Another statement in this law about the health and safety emergency information states that nothing in this act or in this part of the act shall prevent an educational agency from including in a student's education records disciplinary action against the student for conduct that poses significant risk to the safety or well-being of anyone. So you might be having information or notes in a student's file, and it's okay to have that kind of information in there, and it probably should be, as it probably could help in some future situations. So don't think that you should not include disciplinary actions, behavior of a student in an education record, because you probably should. It could be helpful at some future point. This clause is lengthy, but what it refers to is when there is an emergency situation or the health or safety of students is at stake. So I'm going to read this with you. In making a determination, an educational agency or institution may take into account the totality of the circumstances pertaining to a threat or the health or safety of a student or other individuals. It may disclose information from education records to any person who knowledge of the information is necessary to protect the health or safety of the student or other individuals. So again, that's your decision when a situation is going on and you're wondering, oh, should I release that information? Yes, you probably should, because the individuals that are there to help are going to need that information. But along with that, what it's stating is that, again, it's a lengthy sentence here, but what it's stating is that then you must record that threat and that formed the basis for your disclosure of that information to the necessary parties. That's all this is saying. So I've mentioned a couple of times people that have legitimate educational interests. So who are those people? Well, if you're watching this, you're probably one of those legitimate educational interests. They're administrators, supervisors, instructors, support staff, board members, health, medical staff, law enforcement, persons with whom the district has contracted to perform a specific task, parent or student serving on an official committee. So all of those are people that have legitimate educational interests. Some of your special task people that might be attorneys, auditors, medical consultants, therapists, evaluators. You have a lot of people that do have legitimate educational interests, and therefore you can release education record information to those individuals. I know some districts routinely disclose students' names, addresses, and telephone numbers, say, to military recruiters, and that is fine. That is directory type information, and remember, that's not an education record. So it's perfectly acceptable to release that kind of information. Now here's some school districts I want to also say are very specific in their handbook or their rules and district policies about the types of information that they will release and to whom. And a lot of times school districts post this information on their website, so that way everyone knows what can be released. So here's some examples of other school officials and legitimate educational interests that you see listed on the screen. Another piece of information in the law specifies that you should give an annual notification of rights to the parents as well as to students 18 years or older, so that they understand the types of information that is directory information, educational records, and so forth. And most of you do these kinds of things already. Maybe it's something that the parents sign upon enrollment. There's a lot of different ways that you can do this, and actually the way you do it is left at the discretion of the school. It's not stated in the law. So here's some ideas and information of how to avoid some FERPA violations. One of the things that could happen is a parent or a student 18 years or older could request that there be a FERPA hold on the information, and that would be in written form and it would be in the student's file. So you always want to check to see if there is a FERPA hold on information before you release anything. Shredding information makes common sense. Not leaving information that's sensitive on a computer screen, papers on your desk. You never want to discuss confidential information in a manner in which others who do not have a legitimate interest in knowing such information can hear. And I'm just going to give you an example. You're at the show with a friend and you start talking about a student and what is in their educational records. That's probably not a good idea because you just don't know who is within hearing distance and could pick up on that information. You want to be careful about discussing grades or anything else about a student over the phone, in email. Just use some common sense with all of this. And you do not want to share student educational record information with other school officials unless there's a real interest or reason exists. In other words, just don't gossip about things that you know about a student. Here's some other ways to avoid violations with FERPA. Might not want to use students to handle anything having to do with grades or graded materials. That way you won't run into any problems. Don't use the student's name or social security number when posting grades. Talked about that earlier. This may seem to contradict allowing the peer grading, but this is referring to graded materials that are now a part of the student's educational records. Keep remembering that. Grades that you have recorded. I know all of this seems like a lot to absorb, but just remember this simple rule. When in doubt, don't give it out, and then you're probably going to be okay. What I'm showing here is an address where a parent or eligible student can file a complaint against any institution if they feel like their privacy has been violated. You can either pause this webcast to write this down, or you can click on this. It is a hyperlink. It'll take you directly to that website. The same thing on this one. This is a section-by-section analysis if you really wanted to go through the entire FERPA regulations. Thank you. Enjoyed visiting with you today. Bye.